So good evening, everyone. My name is Richard Nettleton. As Haley explained, I'm a solicitor at SEN Legal, and tonight's sort of fourth webinar will be about recovering funding for schools. Sort of just to start off with, though, the usual disclaimer about material contained inside the presentation is for personal use, not to be reproduced, relied on, and obviously seek specific legal advice in your set situation or set of circumstances. So tonight, the key topics that I'll be covering in this presentation is the age-weighted pupil unit, so element 1 funding, the notional budget or element 2 funding, top-up funding, which is element 3, recovering funds, the sort of process used to do that, and then what else you can do to improve funding. So to start off with, the next few slides are going to be sort of about building the foundation of how the funding comes into schools. They are very simplified versions of the operational guidance that provides funding for schools. However, that they will give you a sort of insight on actually how the SEN budget is made up and what money is going into schools. So element 1, also known as age-weighted pupil unit, is the amount of money that's provided per pupil per school. So historically, that was £4,000 for a mainstream pupil and £10,000 for people in a special school. However, LAs every year when the operational funding guidance is released are able to amend these amounts that are provided to schools based on age and only have to comply with the minimum values. So if you look at some of the minimum values this year, some of them go as low as £2,000 depending on the age of the child. So historically 4,000 and 10,000, but they fluctuate each year. So the notional budget for schools, or element 2, SEN delegated budget, it comes under various different names, is actually nothing to do with SEN, even though it is used as the SEN funding for schools all the time. It's, I will come on to £6,000 in a minute, but as you can see there, that diagram below isn't my own diagram, it's the diagram from the high needs funding guide, or from the operational guidance by the Department of Education. And you'll see very clearly that SEN isn't featured anywhere inside that. It's a sort of, I suppose it's an affluence, as I put on the presentation there, it's indices of deprivation. I mean, you've got everything from free school meals into that calculation, disability living allowance, population, all of that. None of that is SEN related. However, it's now become adopted as special educational needs funding. The magic number, £6,000. So you will hear about £6,000 all the time when you enter the sort of world of SEN, and it's banded about that schools have this imaginary amount of money. It's not contained inside any legislation in this country whatsoever. It's also not the test for an EHC needs assessment. It's a figure that originated in the late 90s, as it was basically £10,000 for a special school placement minus £4,000 gave you the £6,000. And the argument was that if a school or academy, mostly schools at that point, could show £6,000 worth of spending, they were providing provision for a child who'd be receiving the same as if they were attending a special school. That figure has then perpetuated itself continually through LA policy, back into high needs funding guidance, things like that. It's sort of a self-perpetuating figure. So, as I said, the LAs took this assumption inferred by the guidance and included it within their policies and used that as thresholds as opposed to actually what was in the tests were. And obviously, you'll see from the Children and Families Act 2014 that isn't the test for an EHC needs assessment. The Department of Education, in their newsletter of 2014, and I'm going to read this out verbatim because it was issued to all local authorities as a very clear guide to the £6,000. So it's contained within the Department of Education newsletter to local authorities on the final page, October 2014. You can find it if you want to Google it. The question is, what is the position on the transfer from SEN statements to EHC plans for those with support needs under 6K? The reply back to that to all local authorities was the statutory definition of SEN has not changed, nor has the guidance in the Code of Practice or when to assess and when to issue a statutory plan. 6K is not a threshold for access to EHC needs assessment or to EHC plans. Decisions about provision must be made on an individual basis. Under the new system, as much as the old. There cannot be a blanket policy regarding eligibility. Local authorities need to work with schools, young people and parents to determine how best to transfer SEN statements to EHC plans. It is recommended that a transparent and phased approach to develop parents and students. So the Department of Education at that point were very clear about what the £6,000 meant. And obviously it has now been amended and altered and means lots of different things. But it goes back to the point on my previous slide, 2 previous slides, about the graphic, that SEN is not part of the calculation that builds what is referred to as the notional budget that comes into schools, but yet again, it is used to provide that funding. So how to work out your notional budget per student. So broadly speaking, you take your total budget for high needs funding, full notional budget, element 2, whatever your local authority calls it, you subtract the cost of free school meals. Now, these are legally ring-fenced free school meals. They're covered by a completely different piece of legislation. However, they have to come out of that funding because they go into the calculation in the first place. Once you have that number, you then need to divide it by the total pupils with EHCPs and all who are on the SEN register. So basically all total SEN students. As a way of example for this, we regularly undertake this work through tribunal work for providing costs and also representing schools. We've seen this figure as low as £500 per student, which is obviously a massive gap in a school's funding. And so far to date, I've never seen a school with £6,000 per pupil. It just doesn't happen. If anyone does, then that's fantastic. But I don't believe when you do this calculation, you will end up with that amount of money. So moving on to the final thing, element 3, top-up funding. So top-up funding is the funding required over and above the core placement of element 1. This is paid by the local authority when it places pupils or students and should reflect the additional support cost an institution incurs relating to the individual pupil or student's needs. Top-up funding is a normal part of funding the element 3. LAs often do it in bands. Usually these bands don't cover the amount of provision that is required, particularly when issuing an EHC plan. It's important to note that the top-up funding can come in 2 forms. It can come in the top-up funding, high needs funding that is attached to an EHC plan as element 3, but it can also come as sort of a discretional one that the LAs have put through, which is just high needs funding. It has early years interventions. It's got different names in different local authorities. The element 3 funding that comes with an EHC plan is enforceable. The element 3 funding that doesn't come, which is just part of high needs funding and things like that, is completely at the local authority's discretion. So if you don't have an EHC plan involved in the situation, the local authority can remove that funding from an institution, and they are doing it quite a lot in a lot of cases to recoup money while children are at home and not in school. Obviously the case law there of RV Cumbria, says that funding bans can be used, but at the end of the day, it's not an alternative to providing the cost of provision. So what should happen? And ultimately, Section 42 is the go-to for this. Local authority must secure the specified provision within the EHC plan. Now that trumps the operational guidance at the end of the day. Guidance is simply guidance. While that, local authorities like to come back and say, but the guidance says, any contradiction in the guidance, Section 42 overrides that. However, going on to the guidance, particularly September's issuing of the high needs funding. However, the final allocation of funding must be sufficient to secure the agreed provision in the EHC plan. So you've got, broadly speaking, the 2 documents saying exactly the same thing. These 2 statements make it clear that the level of funding provided by the LA needs to be sufficient to secure the agreed provision, and that the LA must secure that provision. So it's not for the schools to have to sort that out. This is a local authority responsibility. Further, while the operational guidance isn't law, it indicates that agreement should be reached between the institution and the LA to the level of funding. So at the end of the day, what it's going to cost you to provide that provision should be what the LA is paying you, not just simply sticking to the band funding and saying it's band 3, that's all we provide. What's really important is the word agreement. A lot of the time, local authorities say, because it's local authority money, it's a one-sided agreement, they just have to do that. That's not correct at the end of the day. if they suggest that, you just go back to Haining v Warrington. That argument was lost 7 years ago when the Court of Appeal held that local authority is required to include all its costing, all public expenditure. Schools are public expenditure, so are social care costs, so are health. So it's erroneous to say that it's just the LA's money that they need to consider. They need to reach an agreement with the school about how much money is required. However, what actually happens is normally due to lack of specificity and quantification in the EHC plan, the LA decides to top up funding or applies a banding model without seeking agreement, which does not reflect the amount of provision that is required to meet a young person's needs. Ultimately, the school ends up providing a provision inside a plan without the appropriate level of funding to reflect the true cost of provision. So the key that you need to take from this is specificity. A properly quantified and specific EHC plan controls the level of provision and therefore is your key to making sure that you're paid the right amount for that EHC plan or recovering that money. So provision in section F, these are examples of real provision and they were covered in James's presentation last week, but it's important to highlight this because this is the main centre point for your argument about the funding that is required. So examples from real EHC plans: access to one-to-one support when needed. X would benefit from access to a specialist dyslexia teacher throughout the school year. X will need an intervention to support her social interaction, conflict resolution, and her general skills. So if you just take some of the issues with some of those statements, and I'll focus in on number one in a moment, all of the above wording is not sufficient for section F and lacks specificity and quantification. If a school is providing the provision, it will be costing money. Depending on the level you're providing, this may and normally is more money than what the LA is providing based on this wording. And using the example of access one-to-one support when needed, when you challenge the LA because X needs one-to-one support, the LA is able to argue the decision made by the school due to the wording provision and often term this over-provision. Over-provision is a very common phrase by local authorities, making out that schools have provided more than what a student needs, despite it being clear that the student needs that support and therefore the LA needs to pay for the costing of that. So specificity and quantification. In order for provision to be properly costed, it must be specific and quantified. I'm going to use an example of SALT provision just to sort of go through, but that has to come from an HCPC registered SALT for it to be included in section F. So all of the examples that I've put up on the screen there, the time it takes to design and monitor the program in the first instance, how often the program should be updated, termly, halfly, some other period, how long the initial design, the amount of time for reassessment at the annual review, the amount of time to be spent in direct therapy, liaison time, the time the speech and language therapist needs to manage the structured program, what is the nature and content of the program, how often should the program be delivered, what should be the skill mix of the person delivering the program, what should happen when a member of staff leaves, what training is required to replace said person. All of that should be contained, for an example of SALT provision, inside a child's EHC plan. We see plan after plan where that isn't included, and you then have the issue of providing said support and parents missing that provision for their children, while the local authority is simply saying, well, it's covered by your notional budget, you've got £6,000, go off and do it. At the end of the day, it's section 42 again, which is the LA must secure that provision. Two cases down there, B&M and Oxfordshire confirms the level of specification that's required. And then you've also, if you want to take it right back, just on the SALT example, RV Harrow confirms speech and language therapists must specify the frequency and length of sessions. And while, we hear all the time that there are some therapists out there that will do that, particularly working for the NHS, a lot of the reports we see are missing this specification, and it's worth highlighting to them that it's been some time now, it's 1997, those reports need to change. They need to be quantified and specified. So provision in section F, good examples of real provision I've just put up on the screen there. So full-time one-to-one support throughout the school day, including at break and lunch times, from a teaching assistant with experience and training in working with children with ASD and speech and language difficulties. And then you've got the other examples there, but those are all examples that you can actually put a realistic cost attached to. And if that's not being funded properly, then you've got challengeable grounds to the LA not providing that money. So what do you do to resolve the issues? Ultimately, ultimately schools do not have access to the SEND tribunal. You don't have a right of appeal in the same way parents do. Therefore, judicial review is your only option going forward. Briefly, judicial review, I know it's been talked about in other presentations, but I'm just going to cover it off again for anyone who's new joining us. It's a mechanism for the administrative division of the High Court to review the lawfulness of a decision or action made by a public body, in this case, local authorities. The first step is what is known as a pre-action protocol letter. It's a formal letter to the local authority's legal team and usually Director of Children's Services, setting out the alleged breach, either failure to quantify or specify provision inside an EHCP plan or failure to provide funding. Both are very linked together because one controls the other. The local authority will have 14 days to respond to the PAP letter. That can be shortened in certain circumstances, but the general rule is 14 days. You do not need to have exhausted the local authority's complaint procedure in order to issue pre-action protocol against the local authority. Schools do not have access to the local government ombudsman. I have seen it before from a local authority officer who suggested that they hadn't exhausted all routes. It's just not accessible. The ombudsman is very clear that they won't take complaints from schools. However, the case of Medway Council in 2019, which was an academy that had issues with the specificity of a plan and provision that had been removed from it, that judgment confirms that a complaint to the Secretary of State has to be made before a judicial review claim can be considered or, I suppose, lodged in that respect, because you have had to have exhausted all of the options of people that are able to influence the LA's decision. And ultimately, the Secretary of State for Education can order the local authority under the powers that that department has to comply and to make corrective action. However, we'd always say you need to take legal advice in relation to pre-action protocol letter and judicial review proceedings. Just one quick slide, because this is coming up actually more than we've ever seen before. If you've not been paid your top-up funding at all, despite it being agreed and in relation to an EHC plan. So if you go to the operational funding guidance, it emphasises that payments should be made monthly. It clearly says local authority must make payments top-up funding to institutions in a timely fashion and on a basis agreed with the institution. Payments must be made monthly unless otherwise agreed. That is very clear. If you're not receiving your element 3 top-up funding despite it being agreed in relation to EHC plans, that is an immediate complaint to the Education and Skills Funding Agency. You may require legal assistance in order to do that if they can't resolve the issue quickly. However, ultimately, that money's been paid to the local authority. That money should then be paid to the school. The question is, where has that money gone? And as I said, there is a sharp increase in that happening either through poor administration or withholding of funds, that schools need to check that they are receiving that money. So the process for recovering funds can take some time, but I need to stress again, schools do not have access to the SEND tribunal. So once a funding deficit, failure to specify an EHC plan, normally plans, it's not usually one plan from a local authority, it's multiple, have identified the LA is and you've contacted the LA and they're refusing to address this, a pre-action protocol letter is sent to the LA and that's responded by the legal department. Local authority responds to the claim. If that is not sufficiently addressed, it's a complaint to the Secretary of State for Education. If the Secretary of State responds and that does not sufficiently address the issues, then you've got grounds to launch judicial review or potentially grounds to launch judicial review. You then be in a situation of launching proceedings, awaiting a permission decision, which is judge looking at it saying you have a case you can proceed on, and then a hearing. Judicial review can be expensive and time consuming, so it's always worth doing a thorough cost benefit analysis. But sometimes when schools contact us, they are missing thousands. The cost of proceedings outweighs the total cost of what is being recovered. So it's always worth making sure your finance team is thoroughly looking at this to see actually how much money is outstanding. So this slide's headed, that sounded great, what's the catch? The problem with everything that I've described before is that there is insufficient money in the system, and the guidance that how to work this out and how to navigate it is either defective or intentionally vague. It's in equal measures. with the lack of funding, you have to bear in mind that when you raise these challenges with the local authority and then ultimately the Department of Education, that the local authority does not want to spend additional money correcting this issue. The Department of Education, thereby, when they receive the complaint, don't want to admit the system is broken for numerous reasons, both financial and political. And of those numerous reasons, most importantly, the Department of Education don't want LA sending them the bill for missing money. They've delegated the money out to local authorities to schools. That's where they want the matter to end. They don't want to have to start trying to top up or change the formula. And the cycle is then perpetuated year after year, with damaging consequences to children in the country, not having the provision that it can meet their needs, or practitioners providing that provision, and then running into a deficit, and you've got issues with school finances going forward. So judicial review is the ultimate resolution of these issues. The next few slides will cover what else can be done, starting off with the first one, which is just a complaint to the Secretary of State for Education and the Education and Skills Funding Agency. Academies and schools have a right to complain about LA conduct. The problem with the Department of Education and the FSA is it's filled with administrators and not lawyers. So when you're stating Section 42 as your argument, sometimes they don't understand what that is, and it requires more explanation, or they simply ignore it and say it doesn't count. It's not relevant, which is incorrect. Sometimes also their knowledge of SEN is limited, as demonstrated by the third bullet point, which is we received a decision midway through last year where the Department of Education ruled in the local authority's favour on a particular point that dyslexia was contained in Section C of an EHCP. It should be in Section B. There's no argument that I can see for it being in Section C. And that was a real decision that was reached. And any practitioner who's listening to this now will go, that is ludicrous, that shouldn't have happened. But unfortunately, that if you don't have an area, if you don't understand the background to SEN and how the EHC plan works, you can reach decisions like that. This is a low cost option to litigation, but again, I highlight the issue of this isn't lawyers dealing with this issue. This is often administrators. The two leading cases in schools challenging local authorities in relation to statements and EHC plans is the case of Medway and Queensmead. Both examples, despite being, I think Queensmead is about 1998 and Medway being 2019, the Department of Education officers found in favour of the LA, and they were both overturned by the High Court, which just emphasises DfE are not lawyers, and I sometimes feel just with former LA officers who understand the policy of local authorities and believe that to be the law, and that supplements Section 42 and things like that. That is not correct. And the court will do the job properly if the Department of Education fails. So part two of what else you can do, or what else can you do to increase funding. Annual reviews. Use the annual review process to make your recommendations to the plan in terms of quantifying and specifying provision. Make those recommendations, highlight to the local authority the plan is defective. While you cannot rewrite the plan, that is the local authority's responsibility. Highlighting that so that parents are aware of that, so that parents have the ability to go to the tribunal and have this corrected, because ultimately this controls the money that's coming in, as that'll impact the top-up funding. It's really important to make sure that Section F is properly quantified and specified. It's the key to all of this and claiming costs and being able to show that actually through provision maps you are being underfunded by the local authority for the provision that they must secure. Part three of what else you can do, what else can you do? Parental rights, whether that's EHC needs assessment requests, decisions for annual reviews, they all carry right of appeal to the SEND tribunal. Now, while you as a school cannot access the SEND tribunal, parents can, and sometimes they're not aware of that. Local authority officers said they cannot go to appeal, all of these kind of things, despite it being a requirement in the letter that comes with annual reviews and finally EHC plans. There are a lot of myths that are out there, either through lack of training or attempts to actively mislead and discourage appeals. In the case of failing to update an EHC plan, sometimes it's normally for many years. We sometimes still see references to nursery in young people who are 16 years old. Not specifying or quantifying the provision, or not including provision that is required to meet needs despite the evidence being presented. These are all matters best dealt with the tribunal. The tribunal will not take into account local authority policy where they're saying I won't update the plan until secondary transfer or things like this. You know, we see it all the time. The tribunal will update the plan as a result of the appeal. So help parents to submit. There's a lot of resources online, but help parents to submit these appeals. You know, point them in the road of the tribunal. You know, the SEND tribunal is not going to allow EHCPs to continue to remain in a form that is contrary to legislation, regulations and case law. It doesn't fix the national problem that plans are issued with very little regard to the law. However, it corrects that case on a case-by-case basis. And then parents start to be able to navigate the maze. They start to realise what a good plan should look like. And parents exercising their legal rights ultimately help schools and academies in this area of funding. So what else can be done? Part 4. So request more top-up funding. At any point throughout the school year, you can request more top-up funding from the local authority or case officer or whoever it is that's in contact with your school. The key to doing this is provision maps, being able to detail out through quantified and specified provision that funding is deficient. It isn't enough to cover that child's needs. And again, stating section 42 that the LA needs to provide that. Now, some LAs are better than others and will review this and increase. Sometimes it's not the biggest amount of increase, but they will have a look at the matter. Others just flatly refuse, because that is about protecting budgets, or sometimes they know that the plan isn't specified and quantified and then refuse to do that. That's a situation where you want to seek legal advice to enforce that. The other thing that you can do, and this is a sort of massive one, particularly when you're looking at schools who have got high needs funding for students without EHC plans, because ultimately LAs can withdraw that at whim under the guidance, is helping parents submit EHC needs requests. Now, a lot of schools contact us, and we see it on social media all the time, about they've had to fill out 20, 30, 40 pages worth of forms, provided X amount of cycles of plan to review, all of these kind of things, and fill out long forms that are very time consuming. Ultimately, help the parent draft the request and have the parent submit it under section 36.8, complying with the test there, provide the parents the evidence, ensure they sign the request. Therefore, this is a parental request, and providing the parents can prove the request was submitted, the 6-week deadline for a decision begins. While this is the start of the process for an EHCP, a lot of children in schools are receiving high needs funding that would be entitled to an EHC plan, which then protects your funding going forward, and then allows you to claim the true cost of provision instead of just being handed a small amount of money to meet need. If the LA respond by sending long forms, often 30 pages, these are not statutory forms and schools do not need to fill them out. Simply state or list the provision required in a short letter and return this to the LA. At the end of the day, you can always use the line with the local authority of show me where it is in the regulations, show me where this form is. You can be safe in the knowledge that they're going to be unable to turn around and point to where that is. They're going to say it's LA policy. LA policy isn't the law. So just take the firm line with the LA that the evidence has been provided. And ultimately, if they don't agree the EHC needs request, that's a case for the tribunal, and point the parent and help support them through that process. I think I finished slightly ahead of time there, but I think I'm going to be introducing James back now for some Q&As. James?
You are, Richard.
Right, Richard. I'm just...
I need to, there you go. Can you both be seen? Yeah, perfect.
There we go.
Yeah, so thank you for that, Richard. I'm sure that's very informative for a lot of people, but we've got a lot of questions, I will warn you, to try and get through that.
Excellent.
A lot of people want to speak to you and hear from you. So first up is a question from a parent, which is: currently my daughter goes to outside of borough at a specialist school from Newham. I had meeting with the LA and school today for an EHCP review. They completely disagree with the provision I am asking to fulfill my daughter's needs. School said to me, it's your choice of school. If you do not like, you can leave the school. I said, it's nothing to do with the school. I'm looking for Section 8 provision. LA caseworker also seems will not give my daughter the provision. So it sounds like the parent is having quite a bit of difficulty with the provision, having provision put in place,
Yep.
Which might have a knock-on effect with these sort of specialist schools funding. Do you have a sort of view on what you might approach with that?
Yeah, I mean, ultimately, if schools are refusing to let specialists on site, now I need to caveat that with, at the moment, COVID, and that's an understandable reason for specialists not coming onto site. But if the reason is something that isn't related to that, the best approach for that parent, and I mean, it's very rare that schools do refuse specialists on site. So I'm not sure what's happening in that situation specifically, but once, I think you said at the beginning, it was an annual review, get that right of appeal and use that to submit appeal to the SEND tribunal for sections B and F of the EHC plan. Because ultimately, once you've got an appeal running, you can make a request for changes under Rule 15 to request that the tribunal allow these experts on site. That's within the tribunal's power to make sure these specialists come onto site and assess the provision required. Because ultimately, if that plan is deficient in Section F and isn't providing the provision that is required to meet need, or isn't properly quantified and specified, which, as you said, is independent experts, they're usually pretty good at specifying provision, then that's the best way the parent is going to correct that situation. But I would always encourage dialogue with the school first, just to understand what the objection to the specialist coming on site. But ultimately, a Section B and F appeal can be done. You can leave Section I out if you're happy with the placement, to resolve the issues about, what provision should be inside the plan.
Yeah, and I think I'd agree with that. With the right of appeal to the SEND tribunal is the best way to sort that. Another question, which is two questions actually. So the first question is, what is banding, as schools always mention this? And then the second part to that is, in relation to banding, if the EHCP content is poor, does this mean there is anything that we can do about this? Is there a remedy for this? I.e., can an independent ed site take all of this into account, into what they recommend in terms of needs and provision for the child? So I think that's two parts really. What is banding? How can what will a poor EHC plan do to the banding, the school funding that they might receive? So
band funding is normally the local authority's way of having sort of groups of indicators. So 1,000 to 2,000, 2,000 to 3,000 will usually, that'll be band 1 on the first example, second 2,000 to 3,000, band 2. It ranges by a different local authority, but what they want to be able to do is just attribute a bulk financial sum to an EHC plan, and provide that to schools, instead of going through, I suppose, the rigmarole of specifying out that it is, I don't know, £16,000 exactly. If that's not inside the band, they'll want to sort of approximate what the cost is, because that's easier from an administrative perspective for them. However, what often happens is the band funding is not sufficient, and which then ties into the second question, which is if the plan is defective. But if the plan is defective, ultimately what the local authority can argue is that they can provide a lower amount of band funding to the school in order to meet that need, because things like access to regular, all of these kind of things are very vague terms, and they don't contain a specific amount of hours. So you've got varying arguments about whether that will cover, the provision that a student needs. So ultimately, going back to my on one of my slides, which is Section F is your key. If it's not properly quantified and specified, then that is going to impact your funding. Now, an independent educational psychologist is the perfect person to recommend and quantify large chunks of provision. Obviously, they won't be able to quantify the SALT and the OT provision in the plan, but TA hours and things like that, they will be able to help with. But ultimately, the local authority doesn't have to take those recommendations on board. And that's where, again, tribunal appeal comes in. But if that evidence already exists, then help the parent get that into the tribunal, because that's an easy fix for the local authority to make if they're so inclined, to re-amend the plan and end the appeal. Sometimes the matter drags on, but ultimately, when you're doing a BNF appeal and you've got the evidence there, the LAs can have to try and counter that evidence and argue something else in the alternative, and ultimately judge and panel member will make that decision of what should be in Section F.
Yeah, no, I'd agree with that. Just looking at a bit more, is there any sort of judicial review action at all that the school could consider if the EHC plan is completely inadequate with the level of specification, for example?
Yeah, at the end of the day, a school has standing in judicial review proceedings, so you could, alongside a complaint to the Department of Education, but issue pre-action protocol correspondence for the lack of specificity and quantification in a plan. And I think I covered that on one of the slides. It's usually plans from a local authority. It's not one in isolation, that there is a policy of that, and that is in breach of legislation and case law, that the plan needs to be specified and quantified. And ultimately, if not resolved by the local authority, by either conducting more assessments or obtaining the evidence to properly quantify the plan, then they could find themselves in the High Court on that issue. And it's becoming more common for schools to take that kind of action because they understand the impact it has on the children. So while it feels like a very brave move, don't be afraid to do it. I know local authorities come back with a lot of things of, you can't do this, it's a waste of public funds, we're going to do X, Y, and Z to you. In reality, that is threats. It's not going any further than that. At the end of the day, schools have the right to litigate against the local authority for issues such as this. So it's not a waste of public funds. At the end of the day, the job should have been done correctly in the first place. Yeah,
no, I think that's quite right. Just a question leading on from that. Are there any time restrictions to the judicial review route?
Yes, so judicial review claim needs to be brought promptly or within 3 months of I suppose the issue being noticed. Now, a lot of the time that will come off the back of an annual review where the plan hasn't been specified properly. However, going through the procedures of judicial review, issuing your claim letter and things like that, you can restart the time limit from the Department of Education's decision, because ultimately that is a decision of a public body. And you can use that to sort of restart your clock for the 3 months of judicial review going forward. So yeah, it's always worth taking specific legal advice in your situation, but acting promptly when you spot the issue is the key to all judicial review proceedings, because that's what the court expects. They don't expect people to sit on a matter, let it fester, and ultimately practitioners don't do that. They raise issues with the local authority, but if you're getting the runaround from the local authority officer, they'll call you back next week, they'll call you back next week. Those delaying tactics impact your judicial review claim, and it's always worth seeking legal advice how to resolve that if the LA are not willing to resolve the issues.
Yeah, no, thanks for that, Richard. So the next one is, it's not really a question, but it's more of a statement, which I'll just read to you for your thoughts on it, really. It says, the wording in all our EHCPs reads, I take it this is from a school, but it's an anonymous attendee. The school will provide up to 12 hours teaching assistant support per week from its delegated resources of £6,000. The local authority will provide additional funding equivalent to 18 hours of teaching assistant time, which should be used in conjunction with the school's delegated resources to meet the needs which have been identified. So obviously that's going back to that £6,000 point that you've talked about. And I guess there's an element in there, is there going to be enough within that £6,000 to meet that 12 hours teaching assistant support? Because obviously that's quite a lot of support to meet within £6,000. And what I guess can schools do about that?
That wording shouldn't be phrased that way. That's putting the obligation on the school as opposed to the local authority to fund that provision. So I mean, ultimately that needs to be challenged either by the school with the local authority, whether that escalates to a pre-action stage if the local authority are unwilling to amend that, or through the parent taking that to tribunal, because ultimately, while it's not a parent's responsibility to secure the funding for the school, they have the parental right to be able to amend that wording that shouldn't be in there, because that sounds like a classic underfunding of a school. And by saying, well, you've already had the money, you've got to provide that before we step in to help provide anything additional, or will provide it in a very limited. Ultimately, that isn't how Section 42 works or reads. So, I mean, that's definitely one to seek some advice on. But the low cost option is the parent to take that through tribunal to get that amended.
Yeah, no, that's what I'd agree with as well. I'm just looking through the questions as we speak, because those are the ones that we had flagged for live. So I'll just go through the ones that I think are probably the most relevant for most people watching.
Yep.
So the question from Hayley Hemming is, how can schools challenge LA's RE notional budget and banding in the first instance? Should it just go straight to the Education and Skills Funding Agency /JR. Is there a less formal, daunting way initially of doing this?
I mean, the starting one is engaging the local authority in conversation, but a school will know their local authority well over the course of many years. And, you know, while I would always want people to resolve it without the need to resort to legal action or getting the Secretary of State involved in education funding agency, then, you know, so be it. That fosters positive relationships, because ultimately children are at the heart of this process. But if the local authority aren't willing to listen and you've made attempts to engage them in that, then unfortunately legal action or Department of Education is the route to redress. But I wouldn't ever be daunted about contacting Department of Education. While that sounds like quite a drastic step, at the end of the day, they receive complaints daily, weekly from schools about LA conduct, and they strive to try and mediate and resolve the issue. And if they're unable to resolve it or simply don't understand the issue, then unfortunately that judicial review is the next route, unless it's an issue that a parent can fix through tribunal and you can support them that way. But particularly with funding, it's not a parent's responsibility to secure the funds that a school require through their plan. So that is very much a school local authority issue that will require somebody to move on it. If the LA is underfunding you, then you're going to have to take action or accept what they're doing, which, you know, is not ever our advice.
Yeah, no, I think that's very right as well, Richard. So just moving on to a slightly different topic, it's one about the Section 42 duty.
Yep.
So Gary says, there is no need to apply for top-up funding, as some LAs insist. Can we just tell the LA of their Section 42 subsection 2 duty, which obviously the duty to provide the provision in the plan, and give them details of provision and costs, and then ask to be paid for that, for example? Is that a good method for a school to approach such issues?
I mean, yeah, that's absolutely correct. You can definitely do that. The reason I say top-up funding is usually that's how it's controlled by the element 3 funding that's provided. Ultimately, schools have a right under 42 to be provided the entire provision cost, and the top-up funding is sort of a negotiation asking for different bands that might reduce the pressure on schools. But yes, that question is correct in the sense of it's a 42 duty. You need to provide the school all the money to meet the provision. So if you're missing it, go to the local authority and say, this is what you need to provide. The problem is local authorities like to turn around and come up with a variety of ways to say that either you've had the money or they don't want to hear about it, which then sometimes results in legal action to secure that. And that's the reality of the situation, unfortunately.
Yeah, and I think also just touched on that. Obviously, you've got to comprehend what the EHC plans actually look like. So, of course, if they do lack the specification, quantification, it's going to be quite hard to cost the provision to the LA. And often you can end up in disputes with the local authority about actually what should be provided and what their opinion is on it. And if it's not specific and quantified, of course, then you are in a bit ropey grounds with that point.
Yeah, correct. Yeah, the key is section F, and the plans we see on a daily basis that are in circulation sometimes are, you know, there's a high level of support that's required, and the school are putting it in place and doing everything they can, but the local authority simply aren't providing the money attached to it because they haven't properly addressed the provision inside section F. So the school is doing what they need to do, and sometimes claims get made about over provision, which is just not correct. It's not what school practitioners do. They don't provide what the child needs. Local authorities need to sum up the cash for it.
Yeah, exactly. And that's something that I think we have to make clear to a lot. You do need to look at the EHC plans in a lot of detail to make sure they are at that level. One that's just come in, which is one that we haven't really touched on. I think this is a good one because I think you'll have a bit of a strong opinion on this one. Do LAs have to publish their banding, for example, on their local offers? So I guess the question there is it public knowledge what these bandings are? How much money are they giving to schools for the funding of the EHC plans, for example?
I mean, the guidance has always been clear to local authorities that they should be providing this information to all the schools in their area so that they clearly understand how they provide their funding model. I suppose in reality, yes, local authorities don't publish that information and should provide it on request. I mean, realistically, if they refuse to provide it or put it on their website, then a freedom of information request will elicit the information you need. That it doesn't take very long, and it's responded to within 20 working days. So they'll have to provide that. So, I mean, I would always advise the local authority. Well, we don't do local authority work, just to be really clear about that. But I would always say to just put it on. There's nothing. There should be no secret about how the band funding works. But just going back to the Section 42 point, ultimately, while they use the bands, then that banding needs to cover the true cost of provision. So if you've got a properly quantified, specified plan, you've got your provision maps working out exactly what the total cost of provision is, then ultimately, if that exceeds what the band is being provided, then the local authority's got it wrong and needs to address that.
Yeah, and another one that's come in, Richard, which is obviously in relation to the funding.
Yeah.
If a school isn't receiving the money from the local authority, they can't deliver the provision, would they have grounds to turn around and say, well, we can't meet needs, the child needs to go to a different school where the provision can be provided? I
mean, in an extreme situation, that the school would be in that position of having to say that in an annual review. You'd be able to call an emergency annual review to say, actually, the cost of provision isn't being met. That will provide a parent with a right to appeal to the SEND tribunal. There's a lot of hypotheticals about exactly what the provision is in Section F there that would be a very case specific point. However, I would implore a situation not to get to that because of the child impacted in the middle of it. But ultimately, if you're not being provided that, then emergency annual review is going to have to be called. And I'd be advising the school to contact solicitors to resolve that funding issue ultimately to stop, I suppose, a situation like that happening, because I'm aware situations like that do happen, and they realistically shouldn't. The provision needs to be there to meet need, and the true cost of provision needs to be paid. It's a very clear 42 duty. Yeah.
This is a question that was sent in advance for you from a school, I believe, as well.
Okay.
So the LA have just come back to us with an amendment notice for an EHCP annual review, which was submitted in June. Funded hours will increase by 4 hours a week. Can we claim funding for the last term given the LA delay?
So to start off with, there's a small caveat of whether that's an independent school. If it's an independent school, you'd be covered by the NAS contract, National Schools Contract, that wouldn't allow that situation. I'm assuming that's not the situation here. And if I'm anything I say after that point, if you are an independent school, there's a slightly different route about how your funding is controlled in that agreement. Although one thing I would say is the National School Contract, I wouldn't advise any independent school to use. Have your own contract, as that's written in favour of local authorities and you can't vary provision. However, on the assumption that they're not an independent school, which is usually the situation, as the EHCP hasn't been issued, the money's not due. You can ask for it from the local authority and say, look, please backdate because we've been providing it, you agreed it. But from a purely pessimistic point of view, local authorities aren't known for providing cash in situations like this. So, you need the final plan to be able to control the funding. Yes,
and I think that's a sort of question which comes up quite regularly for parents with EHC plans, for example. They often ask, will we get fees back from an independent special school if we've been paying for them before an EHC plan is issued? And of course, unfortunately, the answer is no to that. Unfortunately, it's when the EHC plan is in place, the funding then falls due. Another question we have in advance, Richard, is we have a child with 2-to-1 support in school. The child is currently shielding and the LA are looking to withdraw funding. We have to pay our staff. Are they able to do this? The situation is slightly complicated as we are funded to have her in school for 2 whole days and 3 mornings each week. She is so unwell that when she's out of school, the LA directly funds 2 home provided carers. However, the arrangements have always been that we are paid regardless.
Okay, in that situation, my first question is, where does the 2-to-1 support come from? Is it contained inside an EHC plan? If it's from an EHC plan, then the Section 42 duty applies, and no, they can't pull the money. However, if it's in the situation of the 2-to-1 funding just comes in high needs without the EHC plan, then unfortunately the local authority are in a position to be able to pull that funding. It's in the guidance. It's effectively discretional funding. I would say in that situation going on, if there wasn't an EHC plan involved, then I would make sure an EHC needs assessment was applied for sort of pretty rapidly, because at the end of the day, once you've got an EHC plan in place, that will protect that. So yes, that money's protected in an EHC plan situation under section 42, but it's not protected if there is no EHC plan.
Right, okay, that's fine. Yeah, I think that's right, Richard. Just another question following that, which leads on from what you actually said there, which is the EHC needs assessments. We have a nursery child for whom an EHCP needs assessment was agreed in August. However, the assessment is still incomplete. We currently have early years exceptional needs funding in place. The LA have advised us that as she is not currently in school, we will not receive funding. However, would we have done it if an EHC plan was in place? Should we be penalised for this?
I mean, that's a commonly found situation. My answer is no, you shouldn't be penalised for it. However, because there is no EHCP in existence, there is no entitlement, and that drives your entitlement and your protection to that funding. I mean, you know, there's a potential argument for a complaints Department of Education there, just for the LA's conduct in that matter, particularly under you've also got the parental grounds for the PAP letter, for the fact that, you know, that's August, that should have been concluded by now. You know, they've clearly overrun on timescales. I mean, a school would have sufficient judicial review standing to bring that PAP letter themselves, actually, for the failure to complete the timescales going forward. But obviously, the parent is the best route for challenging that. And I mean, a PAP letter isn't the most expensive thing in the world to do, and I would always advise parents to go down that route, because otherwise that's just going to carry on. But no, ultimately, no, you shouldn't be penalised for it. You would have been covered by a plan, but the delays in the plan mean, or delays in a plan being issued means you have got no right to sort of protect that money. Yeah.
No, so thank you for those, Richard. What I think we're going to do is to give you a little bit of a break from speaking, because obviously you've been speaking for 55 minutes now, thoroughly. We've still got quite a few questions to get through. I think we've got 12 still open, or 13 to get through. So what I propose we do is, we will now do is sort of stop the videos and answer as many questions as we can in the Q&A box. So if you do have a question, obviously we will now get to them. We'll now spend the next 5 or 10 minutes or so going through those, because obviously we're conscious to finish roughly around the sort of time that we did say. Now, of course, this is the last live webinar that we are doing. Obviously, we've done the 4 that Hayley mentioned already, and I understand that Melinda will also be doing one on disability discrimination, and that'll be pre-recorded, so you can log in and watch that. So obviously keep your eyes peeled for that. But I think unless Hayley's got anything to add, I think we'll now go to the Q&As, just typing them in as we go.
It was just to say thank you to everybody for joining us, James. Obviously, this is the first webinar we've done dedicated for schools specifically, and hopefully it's been useful for those schools and professionals that are listening in, because certainly from answering some of the questions this evening, it's been quite obvious that lots of local authorities are telling schools that it's their duty to draft the EHC plans, which obviously it's not. It's for a local authority. And also a tribunal can draft an EHC plan, but not the school. And there seems to be a lot of unnecessary forms that are being put on schools. We do have a dedicated website for schools work, SEN Legal for schools.co.uk. So certainly go on there and have a look at that. And for schools that are watching, if there are other resources that you think might be helpful to you in our work for schools, please do let us know. All of these webinars are generated from the information that we get from parents and from schools. And our ultimate aim is to make sure children with EHC plans and children with any additional needs are supported as much as possible, whether that's through the tribunal route for parents or through schools making sure that the correct funding is there. So we really hope you're finding the webinar useful. Please feed back to us. Me and my team are so dedicated to getting the right information out there for you. So we'd love to hear your feedback on our social media. And like James said, we'll just hop on and answer the remaining questions that are in the Q&A section. And I've just seen that our assistant has just popped into the chat our website for schools. So if you are a school and want to check that out, please do so. But thank you very much for joining us tonight. It's always a great pleasure to join us and spend your time with us. And we hope you found the session very useful. So thank you.
Yeah, thank you very much.